Greetings, my fellow freeloaders, silent thinkers. This is L3's newest podcast. My name is Craig, transmitting from the beautiful swampy mangroves of South Florida. And today's date, Tuesday, July 11th, 2017. And what you heard was a performer named LECTRIS, titled Be Free, which is a royalty-free song. And I have to thank Angelica for requesting that. Heard one of my episodes, left a comment, enjoyed the video, and say, hey, you play this, and request has been granted. And anyone else that has royalty-free music, or something that you'd like to put out, if I like it, yeah, I vary. So you just I'll put something heavy on there, or something with a cool little beat, little taste of fusion. Why not just a little variety? So, hey, hopefully folks like it. I'm going to play at the end of the show as well, and add a link for the tune, okay? So let them know that Look the Third sent you. All right, well, I am at CJ's Java Lounge, located at 400 Southwest 1st Avenue, Suite 1, along the beautiful New River of Fort Lauderdale, in the building called the Yacht Club, which is within the southwest section of the Andrews Avenue Bridge. So I'm going to be addressing a topic which I find very disturbing. And it's a reference to a gentleman named Dale Norman who was arrested and convicted of a second-degree misdemeanor for having his gun open in Fort Pierce, Florida. Happened a few years ago. And the video is a quite turn-off. It shows some of the folks how manly they are, because if they're a governmental delegate, you can do what you want. And everyone else got to be just peasants under their wing. Even though he had a concealed carry permit, this is his first time walking around, just getting comfortable. And Fort Pierce along US 1. Then the video showed him getting arrested on the ground, and some of the cops are running. He's being corrupt, they're like running, like, yeah, I got someone to arrest. I'm a man. I'm a woman. I'm tough. I support victimless crime laws. It keeps me busy. So, we're going to be talking about that, and we're going to go through some of the court cases, and it is going to the U.S. Supreme Court. I'll be addressing the statutes, and plus the Florida Constitution, and in addition, that natural right to bear arms is a natural right, not just constitutional, but a natural born, God-given right. If there's no victim, how's that a crime? And hopefully, folks that listen to the show, even if you become a potential juror in a case like this, you should always learn about jury nullification. No victim, no crime. So, based on what I read, Mr. Norman was convicted of a victimless crime law. And I find this completely unacceptable, and even some of the opinions from the Florida Supreme Court bellied up. And maybe the flaws, too, on one of the flaws I've observed, too, are some of the transcripts with who's representing Dale Norman as well. But it's like no crucifixion, because remember, life is a learning experience. So I'm going to be reading some of the articles. And right here is from Sunshine News. It's by Allison Nielsen. So it's mainly going to be focusing on the Dale Norman case. So it'd be actually called Dale Norman's open carry case goes to the Supreme Court of the United States. It'll be the acronym for the Supreme Court, of course. So he says here, Florida Carry takes Norman open carry case to U.S. Supreme Court. A Florida group has filed an appeal in the U.S. Supreme Court in a case dealing with how Florida regulates open carry for weapons and firearms. On Monday, Florida Carry Inc. filed an appeal in the U.S. Supreme Court in the Dale Norman versus Florida case, a case revolving around how Florida regulates concealed weapons permit holders and the accidental branching of firearms. It all started in 2012 when Dale Norman was found guilty of second-degree misdemeanor after his firearm accidentally became exposed outside his house. Norman was walking down the street in Fort Pierce carrying his handgun, which was not covered by his clothing. When a passerby saw the gun, the police were called and Norman was arrested. Yes, a passerby. Sweet Polly purebred. Underdog. Save me. I can't even wipe my own behind. Thank you for choosing poorly, whoever you are. You're just a wuss as far as I'm concerned. A lower court found Norman guilty of violating the state's open carry ban, even though Norman had a concealed weapons permit for his handgun. The court slapped Norman with a $300 fine and court costs, but the legal challenges didn't end there. Norman alleged state lawmakers were wrong in banning open carry because it requires people looking to defend themselves first to get a concealed weapons permit if they ever want to protect themselves while outside the four walls of their home. The state, on the other hand, believes that if open carry were to be legal, legislators will have to pass a bill allowing it. Huh? Yes, I want them to think for me. Come on. Well, I will explain that later. Norman case weaved its way through the court system until it was ultimately heard by the Florida Supreme Court last year, which backed the state in the appeal. Now, Florida Carey and Norman are taking the case all the way to the nation's highest court, alleging Florida has erred in its 30-year open carry ban. Florida Carey says a ban on open carry goes against the spirit of America, which typically tends to support the right to bear arms. Traditionally, this court and the state courts have viewed the right to bear arms as categorically protecting the carry of firearms openly, the group wrote. Florida and the other four states that generally ban open carry are outliners in conflict with American tradition. The case gathered the support of pro-gun groups like the National Rifle Association, which quickly hopped on board in supporting Norman and the Florida Carey in the appeals process. Mr. Norman is a law-abiding citizen who has concealed weapons license and was exercising his constitutional right. NRA lobbyist and President Marion Hammer told Sunshine News Mr. Norman is being treated like a criminal because his shirt came up and his firearm was accidentally exposed to the sight of another person. I don't know why you're trying to say that concealed weapons license and was exercising his constitutional right goes hand in hand. With all due respect to Marion Hammer, explain that, because if you folks actually study Black's Law Dictionary, a license means, and I'm paraphrasing, that it's a document, a permit approved by competent authority. So how is this a constitutional right and a privilege goes hand in hand? They don't. They're two separate entities. And I will carry on here. Florida is one of the 5 states to have an outright ban on open carry. The Republican lawmakers have attempted to pass bills permitting open carry for concealed weapons permit holders for years in the voters' legislature. Senator Greg Gustavo, a Republican from Sarasota, filed a similar measure this year, but legislation was never heard on the Senate floor. The Norman case is on the litany of cases that influenced my bill, but the way the court has identified the law in the case necessitated the bill we filed. Satelbi told Sunshine News Monday. Satelbi told SSN he didn't understand the court's rationale in charging CCW permit holders for accidentally revealing their firearms. Law-abiding citizens who have a valid concealed carry permit shouldn't be charged with unintentional displaying their firearms, he said. It's absurd to think somebody who has a legal permit gets arrested for violating open carry, and that's how the Supreme Court is going to file the case against the statute. As far as I'm concerned, we got to throw all those yahoos out there anyway. Time to go make space somewhere else. Stobit says he plans to bring back the measure up for consideration next year. Everybody agreed with an issue that needed to be addressed, he said. Florida Carey said the Supreme Court justice didn't fully analyze the open carry ban. Allegedly, the state did not execute the highest and most stringent legal review, assessing the ban the strict scrutiny test. If the standard of scrutiny is applied to the ban of an open bearing of arms, it should be a strict scrutiny. Florida Carey wrote, Florida ban does not even pass intermediate scrutiny, and the lower court did not even purport to rely on evidence that it does. And they have their view of the brief of the case, which is mainly about mainly about, what was it, taking it to the Supreme Court. So you can look it up yourselves. There's a link for that. And, yep. The link for that talks about the cases. And let's check this out, shall we? Let's just see what happens in here. I'm just like really curious because I've read through it, but it is going to the U.S. Supreme Court. And this is number 17, Daley Norman versus State of Florida. Talks about Florida law provides for license to carry handguns, concealed by prohibits carrying firearms openly. Petitioner who has such license was convicted of openly carrying a firearm on a public street. The majority of the Supreme Court upheld the ban under immediate scrutiny based on conjecture by counsel about why the legislature may have banned open carry. The majority of the Supreme Court justices think the lower courts are right. Go with all due respect. You got folks get amnesia. How does it feel breaching your oath of office under Article 2, Section 5 of the Florida Constitution? All right? Pathetic. And it says here, the issue is whether prohibition on peaceably and openly carry is a lawfully owned handgun infringes on the right to the people to bear arms, particularly by the Second Amendment to the United States Constitution. That issue also involves an extent to which restrictions on the constitutional right may be upheld under a proper standard of review on the basis of a post hoc argument of counsel with no foundation in the legislative record. So this is like 49 pages long. And they're mainly talking about the Second Amendment and all this good stuff, and the Heller case to uphold the ban. So it's very, it's gonna be one interesting case. I'll be very sincere, but there's a link for that, and so it's just really disturbing. It should have never went this far. Okay, never gone this far. And this is why the folks, even as a juror, if you have a jury case pertaining to this, you have the power to nullify any law as considered illegal in your book, in the books, or unconstitutional. Freedom of conscience. So I'm going to continue on here for the next article. This is written by the gun writer. Came out the same day. It says here, Florida Carry Inc. asked the U.S. Supreme Court to hear open carry case, Norman versus Florida. And they have a video on this. And it talks about how the Second Amendment of the U.S. Constitution, Article 1, Section 8 of the Florida Constitution, like some double standards on Article 1, Section 8. But I will continue on here. Florida Carry Inc. filed a request Monday, known as a writ of certiorari, with the Supreme Court asking justices to hear the pivotal case, Daley Norman versus the state of Florida. So you can actually look at that yourselves, and boom, I'll be going to that next on the litigation aspect of it. Florida Carry General Counsel on Friday, Counsel Eric Friday will argue the case along with Stephen P. Holbrook, Ph.D., one of the country's best constitutional scholars and Second Amendment litigators. Holbrook has personally argued 3 gun-related cases before the U.S. Supreme Court, winning all 3. He's testified before Congress, appeared on numerous television programs, and written briefs of the 2 most significant Second Amendment cases ever heard by the Supreme Court, McDonald versus Chicago and D.C. versus Heller. For Heller, he was asked to write a brief on behalf of the majority of lawmakers in both the U.S. House and Senate. According to the petition, here's the key question the attorneys hope to present. Florida law provides for licenses to carry handguns concealed, but prohibited carrying open firearms openly. Petitioner who has such a license was convicted of openly carrying a firearm on a public street. Majority of the Florida Supreme Court upheld the ban under the intermediate scrutiny based on the conjecture by counsel about why legislators may have banned open carry. This issue is whether a prohibition or peaceably on open carry a lawfully owned handgun infringe on the right of the people to bear arms protected by the Second Amendment to the U.S. Constitution. That issue also involves to an extent to which restriction on the constitutional right may be upheld under a proper standard of review on the basis of a post hoc argument of counsel with the foundation of the legislative factual record. According to Florida Carry, Norman was a law-abiding citizen carrying concealed carry license who was arrested and prosecuted in Fort Pierce for violating Florida nearly complete ban on open carry after his otherwise lawfully carried handgun unknowingly became unconcealed while walking down the street. The first time he carried outside his home was his new Florida concealed carry license. This is a pivotal case for anyone who carries firearms, which is absolutely correct. And it will be an interesting case. I'm just one thing. These respectfully, Mr. Holbrook, he's very good, and always give respect to for the Florida carry as well. And I am on their Facebook page, so we do share information and so forth. Sometimes I may just jump the gun at moments. I do admit that, and I apologize. But one thing you got to look at, too, is your natural born rights. Because even in the 9th Amendment U.S. Constitution, you have those limited rights to not be disparaged. So I'm going to add that to the memo as well, and that will be explained. Explained on that. So, which is enumerated rights, which is a reflection of your natural born rights. I know I did a show on that like a few years ago. And it's a long, long time. So I got to admit that. I'm gonna try to see what I can find it at. I saw one cool little website on it, and see if I can find it here. Nah. So, but definitely you gotta really just check it out. So I'm gonna let me see here. I'm gonna look. Constitutionalcenter.org. It's pretty good about it. It gives you a whole rundown on the 9th Amendment. Yeah, this one has a lot of merit. It's the constitutionalcenter.org, and non-enumerated rights retained by the people. Enumeration in the Constitution of certain rights shall not be construed or denied or disparage others retained by the people. So, yeah, I'll definitely add that to the memo as well, just to get folks to good look at that. And that will be in here as well. Boom. So it will be in the footnotes. And, of course, like I said, you have to add that to the fire because it's called more ammunition. Because to be very sincere, you wouldn't be in there organized and just attack in one area. It's called a checkmate. You want to make sure the other side can't refute it. Doesn't matter where you're at. That's part of the Sun Tzu Art of War scenario plan. You want to make sure you can defeat the enemy without any recourse in battle. This is how life is. Lives are full of battles. It doesn't matter what avenue you're at. And so, always got to be vigilant towards it and exercise, like your rights. You got to exercise into the core. Educate yourselves in these areas. Try not to get a lawyer for everything. It's good to have one as contact, don't get me wrong. But educate yourself and share it with everybody else. And I'll be right back. Yeah, sorry about that. Just nature was calling. Okay, so next we're going to be talking about here will be from FloridaCarry.org, and it's about the whole rundown of the Norman versus the state of Florida. Let me just bring this up. That's large size. Let me see here. Yeah, we'll bring this up, and it says here, Norman versus state of Florida is the case of law-abiding concealed carry licensee who was arrested and prosecuted for Pierce for violating Florida nearly complete ban on open carry after his otherwise lawfully carried handgun knowingly became unconcealed while walking down the street the first time he carried outside his home with this new Florida concealed carry license. There's a video for that. You can see it yourself. A St. Lucie County judge denied all constitutional arguments to dismiss the case against Dale Norman. Man, this judge is probably a damn vulture. Does your county need some money, you stupid ass? Excuse me. I'm just like hate being insulted. Because, they're judge, they know more than us. Give them the middle finger at times, these tyrannical ones. While the court made findings that the statute was overboard is facially vague, the court still issued a conviction on its applied standards. Biggest mistake, it should have went to a jury. Shoot. The county court judge also did not fully consider the Second Amendment or the right to bear arms under Florida Constitution, denying those motions to dismiss the case because the right to bear arms is for someone above the level of this court. Like, that judge is so special. I like to meet this judge. Douchebags, yeah. The Second Amendment question is fairly straightforward. Florida courts have clearly found that the carrying of a concealed weapon is a privilege, which absolutely it is. Subject even being banned completely, not a protected by a constitutional appellate court, have held that the retroactive application of new Florida statutes is not constitutional because a license to carry a weapon, concealed weapon, or a firearm is a privilege and not a vested right. Crane versus Department of State in 1989. Florida legislature and Supreme Court have long recognized that there is a right to bear arms outside the home. The privilege of a license to carry a concealed weapon or firearm, recognized Crane, cannot be replaced as subject to fundamental right guaranteed by the U.S. and Florida Constitution. A bizarro world, can we say. The county court did, however, certify a constitutional question directly to the 4th District Court of Appeals as a question of great public importance. The DCA accepted jurisdiction and upheld the lower court's decisions. The case was appealed to the Florida Supreme Court, where the court upheld the decision of the 4th District Court of Appeals. Norman v. Florida has now appealed to the U.S. Supreme Court. See below. Florida carries providing for the continued defense of Dale Norman and seeks to clarify what was the right to bear arms in Florida. Please help us win this fight to bear arms by joining Florida Carry. And there's initial briefs on here on merits of the State of Appeals filed on April 22nd, 2013. Attorney got one to our Attorney General after multiple extensions. So there's some links on here. No one's reply brief. And initially decided on March 14th not to hear oral arguments. There's an oral argument video on here as well, November 6, 2014. And I like what it says here. DCA ruled against Dale Norman. This occurred on February 18, 2015. While the carry outside the home has been established by the highest court of the land, no decision interpreting the Second Amendment can be cited for the proposition that a state must allow one form of carry or another. Because legislators have the right to enact laws regarding the manner in which arms can be borne, it is likewise permitted to forbid the carry of arms in a particular place or manner which is collective judgment is likely to lead branches of the peace. See Carlton versus the State, 1912. Provided a reasonable alternative matter of carry is provided. The motion for rehearing in the 4th DCA was denied. So it's like, I'm going to have some people in the state going to tell me how to wipe my behind or wipe yours as well. So they're like semi-nannies, okay? Mr. French's A Family Affair. If you've ever seen that show, you understand what I'm talking about. The case was appealed to the Supreme Court. Case number SC 15-650. And there's links on here. You can read this for yourselves. And it says here, an opinion. I like these opinions. I like these opinions. This is on March 2nd, okay, 2017. We hold that the Section 790-53 does not unconstitutionally infringe on the Second Amendment right to bear arms as interpreted by the Supreme Court of the United States in Helen McDonald or the Florida Constitution's freestanding right to bear arms, subject to the legislature's authority to regulate the use and manner of doing so, because Section 790.53 regulates only a matter of bearing arms does not impair the exercise of the fundamental right to bear arms. We approve the 4th District's well-reasoned decision in Norman upon the constitutionality of Section 790.053 under the immediate scrutiny. It is so ordered. And you know what? Let's do us a favor. Let's read the open carry of weapons on Florida Statute 790.53. And as it reads here, subsection 1, except otherwise provided by laws in subsection 2, is unlawful for any person to openly carry on or about his person any firearm or electric weapon or device. It is not a violation of this section for a person licensed to carry a concealed firearm as provided in 790.06 subsection 1, and who is lawfully carrying a firearm in concealed manner to briefly and openly display the firearm to the ordinary sight of another person unless the firearm is intentionally displayed in anger or a threatening manner not necessary of defense. So he's just walking around just being keen and cool not threatening anybody, and they convict them on this particular statute? What the hell is all that about? Let's just check out 790.06. And it's mostly licensed to carry a weapons, a firearm, so all that good stuff. So you can look that up yourself. So just to give you guys a heads up. So he's just acting the video. He's just walking around, and some guy one drove by, saw some passed by, saw him with carrying a gun, opened up. Oh my goodness! Run to the hills. That's right. The underdog cartoon came out, traumatized. The guy thinks he's riffraff. Yeah. Okay, guy assumes he's riffraff. Please stop watching those damn cartoons and his bogus Law and Order TV shows. It's Hollywood only. Okay, so there is no threatening matter. All right, two, a person may openly carry for the purpose of lawful self-defense. So there's a little double standards going on with that so-called opinion. All right, so this is right there is a contradiction. All right, on that viewpoint, and of course here the petition for certified file with Supreme Court, which had happened yesterday. Florida law provides for licenses to carry, which a petition for a writ of certiorari. Florida provides licenses to carry handguns concealed, but prohibits carrying firearms openly. Petitioner who has such a license who was convicted of open carry in a public street. The majority of the Supreme Court upheld the ban on immediate scrutiny based on conjecture by counsel about why legislation may have banned open carry. Issues whether prohibition on peaceably open carry firearm a lawfully owned handgun infringes on the right of the people to bear arms, particularly by the Second Amendment to the U.S. Constitution. That issue also involves the extent to which a restriction on a constitutional right may be upheld under a proper standard of review on a basis of post hoc argument of counsel with no foundation, legislative, or factual record. And you can look at all the history of this particular case. Okay, even with the clerk of county court. So all these links are here. But as far as I'm concerned, there's no victim. How is that a crime? All right. To the judges and all that, pathetic. Very pathetic. Judge Cliff Barnes, thank you for being a pathetic fool. You chose poorly, chump. In a jury trial. Oh, they have a jury trial too. I'm pretty amazed. The jury should have been more enlightened as well. That's why the thing called jury nullification. And according to this, adjudication withheld. So they found adjudication withheld. Interesting. So Norman Dale Lee. Dale Lee Norman, excuse me. And the main attorney, his adjudication withheld. So he wasn't really found guilty, but adjudication withheld. So, very interesting. That's what they gave him that particular case. So, there's links on there. You can see it for yourself on this Florida carry site. And there's mainly these court filings. So there's a lot of history in here, so you can really take a look at it. And I'm very disturbed because, like I said before, he was being peacefully carrying, and he wasn't making any threatening or angry. He wasn't no intentional display of anger or threatening matter. So there's no victim on this case. If someone got offended, oh my goodness, this person has a gun. My feelings are hurt. Very sensitive of you. All right, well, speaking of that, let's check this. It's fun. Let's look at Article 1, Section 8, because even in these proceedings in the Florida Supreme Court, I find it very distraught because they use the Second Amendment U.S. Constitution, which everyone knows about, and of course Article 1, Section 8, okay, right to bear arms. And like it says here, the right of the people to bear arms in defense of themselves and of the lawful authority of the state should not be infringed, except in the matter of bearing arms may be regulated by law. So there's a flip-flop here, double standards. Won't be infringed, but we can regulate. Regulation is an infringement. All right? And of course, they have a thing about the 3-day waiting period and all that, and legislation shall enact implementing the subject of this section. Okay, so I was against 3-day waiting period. That was a vote on November 1988. I was like 19 years old. I was totally against it. So, and all these knuckleheads, oh yeah, we support the 3-day waiting period because all the people getting killed in South Florida. But if you to end the drug war, it would have been a little bit different. I can say that. I lived down here for 40 years, folks. So I can make that statement. All right, so right there are some real contradictions. And what to be very sincere, the attorneys, what they should have used is the basic rights under Article 1, Section 2. All persons, female and male alike, are equal before the law and have inalienable rights, among whether the right to enjoy and defend life and liberty, to pursue happiness, to be rewarded for the industry, and to acquire, possess, and protect property, except that the ownership, inheritance, disposition, and possession of a real property by aliens ineligible for citizenship may be regulated or prohibited by law. No person shall be deprived of any right because of race, religion, national origin, or physical disability. So, how come they need to start, everyone in the farms community need to start using that as well? The whole thing on your natural born rights. That's what Article 1, Section 2 is. And, of course, the Ninth Amendment as well. That's the equivalent to it, which I'll read again. The enumeration in the Constitution of certain rights shall not be construed, deny, or disparage others retained by the people, which is mainly your natural born rights. And as a common interpretation from the Constitution Center, we'll give you the rundown of what it means. So definitely take a look at that. All right, and I'm going to add a link on here as well on the handgun laws for Florida. Give you a whole rundown, so if you're coming to the state, you can always know about the laws here. Even though a lot more is unconstitutional, my perspective, variable viewpoint, but it's always got to be ready. And always, folks, here, jury nullification, no victim, no crime, and to be very sincere, Dale Lee Norman was adjudicated withheld of a victimless crime law. And that's a sham, and it costs us money. Why? So St. Lucie County can collect revenue? Pathetic. And the Fort Pierce police should be ashamed of themselves for arresting a good man. And that's just an example. Why? Because you believe you have authority over everybody. Because someone goes, oh my God, that person's carrying a gun. And get him on the ground. He is a real criminal. Manly and womanly of you. Dumbed down, and proud. And I say that in good faith to those individuals that arrested him. All right. Well, another thing I like to address here is actually from the 10th Amendment Center to explain once again under a minute the right to keep and bear arms is a natural right. So let's begin, shall we?
Everyone has the right to keep and bear arms, but it's totally wrong to refer to this as a constitutional right. The right to keep and bear arms is actually part of a broader natural right to self-defense. No government, no document, no vote creates your right to self-defense. You have this right because you are a living, breathing human being. The Second Amendment doesn't create a right to keep and bear arms. What it does is prohibit the federal government from violating the natural right you already have. And that prohibition is absolute.
Thank you, Mr. Bolden from the 10th Amendment Center. I'm going to add that to my footnotes as well, which is a YouTube video on that. And I recommend everyone who is pro-firearms, pro-liberty, pro-natural-born rights, share this throughout your colleagues. Doesn't matter where they're at, whether it's a National Rifle Association, Guns of America, right to keep and bear arms, etc. Florida Carry, people remember Florida Carry should share this as well because this is vital. The message is tyrannical. And a person like myself find this unacceptable on what happened to our brother Norman. So, yes, he was a black man, African American, doesn't matter, but he's still a brother. He's still an individual. And that's how I see the world. And everyone out there needs to do the same. So, my brothers and sisters in Florida, stand up for what's right. Don't rely on legislation and everything. That's just one avenue. Hit other areas as well. Be the teacher, the rabbi. Plant the seeds. Go out and chat with some of the kids out there. And even other folks, just shoot the breeze, man. Just you be honorable in this particular discussion, because you got folks out there are being brainwashed by these mainstream media, which I know the rates are plummeting. People are learning, but you got to get them everywhere under the legality aspect as well. Because if we don't, we can all get burned. And guarantee you this, my friends, my rights are natural born. Yours as well, regardless of your race, color, creed, gender, sexual orientation, etc. As long as you don't violate others. As far as I'm concerned, that's self-explanatory. All right, my friends, I'd like to thank everyone for listening. Plus, feel free to download and share this throughout your social media networks. If you have any questions, comments, or you want to send me something that's interesting and may want to check out, whatever you do, please address your correspondences with decorum. You can hit me on Facebook, Twitter, Google+, Spreaker, iHeartRadio, Tumblr, YouTube, Freedom's Network, Scene.life, Minds.com, FutureNet.club, or Patreon.com/LokiLuck with 3 I's all together. If you want to be a sponsor, that would be fantastic. Or you can email me at LokiLuck3, which is LokiLuck number 3 altogether at gmail.com. Or to the encrypted fans out there, supporters, LokiLuck03, which is number 0303 altogether, protonmail.com. So hopefully you folks enjoy this show. And once again, thank you for your time. Plus, always remember that demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love, and may your guardian spirits be with you.